My book, The Case Against State Protection of Homeowner Associations, was mentioned in the AARP Homeowners Bill of Rights, mentioned by Jan Bergman at the last meeting. Citizens for Constitutional Local Government is also cited in the Robert Nelson book, Private Neighborhoods and the Transformation of Local Government, in which I called for a Homeowners Bill of Rights before the Arizona legislature back in 2000. And I argued that homeowner associations are not really democratic. The committee is charged with recommending legislation to deal with condo and HOA problems. However, without an understanding of the history and background, the people of Florida, the homeowners you see here today, and whom you have seen in the last few sessions, will return next year and next year and next year, as they have in previous years, until their petitions for a redress of grievances have been answered without injury. Without an understanding of this history and background, legislatures across the country will continue to find piecemeal solutions and fixes to complex issues created by these governments and their unique constitutions inconsistent with state and municipality laws. Because this information has not been made to legislators, no guiding policy or principles could be developed to provide a plan of action and to give direction to your decisions and recommendations, which would treat the people of Florida living in these associations in a fair and just manner under the laws of Florida. I have previously provided the committee with the materials that I am now speaking. In Florida and across the nation, we have problems with homeowner associations and have had them ever since the introduction of planned communities in 1964 with the Urban Land Institute publication, the Homes Association Handbook, known as TB 50. 9 years later, in 1973, CAI was formed to deal with problems with association management. It was an educational organization then, but as problems continued over subsequent years, as reflected in numerous studies by university professors, and not by the special interest studies you see today, changes were deemed necessary. In 1992, CAI made substantial changes to its structure and became a business trade group primarily to lobby state legislators. And there is no explicit consent to be governed as required in other arenas involving the surrender of constitutional rights and freedoms. While the purchase contract is signed and initials all over the place, homeowners are the association has not advanced any funds to make it a bona fide mortgage or debt to justify the right to foreclose. This cruel and unusual punishment by the state because of the loss of one's equity in his home far exceeds the debt owed to the association, while the special interest attorneys who wrote these laws receive an unconscionable percent of the monies. While granting boons to these special interests, very few protections are granted to the homeowners. Where are the penalties against board violations? Why can't the homeowner foreclose on a board member who violates his obligations of office? I mean, let's be fair.
Folks, let's smile if you agree. It won't slow us down. Okay, go ahead, sir.
Where is the accountability of boards and management firms as real estate brokers, banks, title companies, and escrow agents are held? The Supreme Court criteria for state actors include such conditions. 1, when there is a close nexus or symbiotic relationship between the state and the private party. 2, when the state exercises coercive power. 3, offers significant encouragement, either overt or covert. 4, is entwined in a private party's management or control. Or when the party is entwined with
rather than speak specifically to it, I just suggest that I think it's an important document for consideration in this legislative session. I really do believe that we have a need for safeguards against frivolous items, liens, and foreclosures, and specifically the large attorney's fees that all too often are accompanying those kinds of situations. And really, I believe it happens too quickly and for too small amounts. I would refer you to not necessarily having to reinvent the wheel. Other states have taken this into consideration. I refer you to Arizona as an example. Much of the Arizona statute is similar to what you see in the proposal from Mr. Beringer. I think that the real problem here is that, in all good conscience, we're all attempting to put Band-Aids on a very large problem. I think the Band-Aids need to continue, but I would suggest to you that situations with regard to, as you mentioned earlier, access to information, the need for a different situation with regard to education, and by that, I'm talking about education of board members, education of the management organizations, or managers individually, and also education of owners. Because in my perception, a lot of what happens occurs because of misunderstandings over what we're entitled to, what our rights are, and who should be doing what. And I've seen a lot of that get resolved when people, as was mentioned here before, get a chance to talk with each other. I think another major area that needs close attention is the need for prompt enforcement of whatever's going to happen. I certainly am not here to cast any stones on DBPR. But somehow or another, either DBPR needs more help or more authority or something that's going to allow it to respond to the needs of the citizens, the unit owners in this state, my opinion. So that's where I'm at. Access to info, education, prompt enforcement, and in that situation, I refer you to, if you don't mind, I'll just read this, just a few sentences from what Hawaii said not too long ago, maybe around 2000. Be of some interest to this. I think that there would be a nice place here for establishing something similar to a small claims court where you didn't need to have attorneys represent you. In fact, in one of the states I looked at, they don't allow attorneys to come in. I'd be happy to talk more about that. Yeah, we're smiling now.
And if you don't like it, then you frown, and we'll know.
Remember, I'm an attorney too, although I'm retired.
Okay.
But I really think that that would be very helpful to the situation because by and large, and I'm personally experienced with this, we wind up in a situation where although you may be right, you're not sure you're right, but you get into a controversy, you spend tens of thousands of dollars in doing it. And it comes out of pockets of every unit ultimately.
Absolutely.
There you go.
Thank you, Jerry.
you.
Representative Urbina.
Thank you. Comment?